There you go.
Unless you've done it already.
I did that, so
Okay.
now we'll just wait and see if people start showing up.
Oh, well, we've got, I just
Got one.
here.
Tim.
Got one. Hi, Dr. Makowitz.
I don't know if is he in yet?
Yeah.
All right.
We got.
Lists. All right. I'm sitting here scarfing down my lunch while we wait.
Oh, that's fair.
Actually, I'm going to hardwire in. I'm going to close this up. Close that. All right. Plugged in. There we go. Tim, looks like Tim dropped off. He'll join back on in a minute. People can watch me eat.
Oh, yeah. Now we've got Dr. Cervantes. Hello.
Mm-hmm. All right. Do you have controls, Noelle, so you can let people talk, mute and unmute them?
I can. I basically can ask them to unmute themselves.
Okay. I think it's recording me eating right now.
No, I paused the recording.
Okay. So that would be funny.
Right? You're going to send that out to everybody. Look.
Yeah.
Oh, we got another one.
We'll give it a few minutes.
Oh, yeah. We'll give people time to hop on.
Noon is right at the beginning of the lunch hour. People are scrambling and doing what they need to do on Friday afternoon. Try to get out of here.
You got any weekend plans?
No.
Big COVID weekend plans.
No, we're taking it easy. I was supposed to be an expert witness in an arbitration this week.
Oh, wow.
I don't know. So we spent the whole, we've spent since February prepping this up and getting it all ready to go.
Mm-hmm.
And then, Zoom is making it almost impossible to try cases.
Oh.
So rather than having me testify after they've spent an extraordinary amount of money getting everything prepped up on this multi-million-dollar case, the arbitrator said, well, just have the expert submit all their stuff on the paper, and we'll let the defense challenge it that way. I'm like, okay.
Wow.
We finished about a 1,600-page report. My secretary is finishing it right now to submit into arbitration.
1,600 pages?
Yep.
Dang.
And they wonder why lawyers are expensive.
Yeah, right?
1,600-page report with exhibits and deposition testimony and all sorts of stuff. And,
Wow. That's impressive.
It's crazy. I don't like it. I don't think it's good for people. There's some value to being able to sit down and tell your story and have people listen. And the way it's going right now, you can't do that.
So you couldn't do the deposition or the arbitration on Zoom? It had to be on paper? Because there is a value to seeing someone's face as they're talking or as you're talking.
I couldn't. They didn't want the expert doing it because it's taken too long. What they found, all this stuff is getting scheduled and set up a year ago. Nobody's thinking about COVID. Nobody's thinking about these pandemics and how it's all going to change. And so in person, we can, in 5 days in person, we can get a lot covered. But on Zoom, because you've got to grab documents and you've got to get everybody on the same page and focused on the same line and doing all that stuff, it just adds a tremendous amount of time. So it's nutty.
I guess so.
I think it's going to be around for a little while.
Yeah, this isn't ending anytime soon.
No. And so we're all going to have to adapt and figure it out. It's a new way of doing things.
Mm-hmm. Well, we've got 4 attendees so far. We can start whenever you are ready.
Whenever you are ready, Noelle, I'm good to go.
All right, here we go. SDDS is proud to welcome vendor member Keith Dunnagan of BPE Law Group. The attorneys at BPE Law Group have been advising clients on real estate, business, and estate planning issues for over 20 years. They have assisted numerous clients in probate, business, and real estate matters and have represented and advised brokers on their professional obligation as well as consumers on their rights. I do need to let everyone know that this webinar is being recorded. If you have questions, please ask them in the Q&A and we will get to them as soon as we can. And with that, please welcome Keith Dunnagan.
Oh, thank you for that very kind introduction. Good afternoon. I'm looking, if you see me look this way, my big computer with some of my notes is this direction. So sometimes I turn and look that way just to grab that information. Good afternoon. I am happy and glad to be here with you guys. We've got a small group. Let's be honest. This Zoom thing is kind of new and we're all being forced to learn a new way of conducting business. I'm very much one of those guys that when I teach, I like to be in front of people. I like to have conversations. I like to discuss things and have a free flow exchange. One of the good things about a small group, we can cover a lot of information and we can get to your questions. So by all means, if you have questions, use that little chat feature, get those questions out, and Noelle will interrupt me. So we're going to cover a few things, and we've all heard, make sure, there we go. A lot of topics, Paycheck Protection Program and the Paycheck Protection Program Flexibility Act. There's a lot of things floating out there. We've been working with a lot of clients trying to make sense of how do we navigate this? What's actually going on? How does this work? How does this apply? What's it going to do? So we're going to kind of talk through some of those issues. I'm sure you guys have questions. I'm sure you've seen a lot of competing information, but the main thing is, you've got to have a good understanding of what's really going on. The Paycheck Protection Program is a fantastic program. It's got a lot of benefits for a lot of small businesses, and I know it's being used well. It had some issues, but it's creating a lot of opportunities and good protection for small businesses. Employment issues, as small business owners, this has probably been one of the most difficult places to deal with as we walk through this kind of COVID pandemic issue. We've seen increase in unemployment compensation. We've seen difficulties in getting people back to work. There's a lot of things going on, and we kind of need to understand as business owners, how do we navigate that? We're going to talk a little bit about the Families First Coronavirus Response Act. It creates a lot of issues that employers need to be aware of, and how do we deal with it? And it doesn't matter what industry you're in, there's impacts, and we want to make sure that we navigate this the right way, because we live in the great state of California, and we all know that in the great state of California, we're heavily regulated, so we've got to understand how do we maneuver through those regulations and maintain compliance, because that's the key. We want to be smart. We want to be sensitive to our client, to our patients. We want to be sensitive to our employees and our staff. But we still have to run the business, and we want to be compliant as we work through it. So you can tell a lawyer's doing this because the first thing that we always talk about is disclaimers. This presentation is intended to be informational and educational only, is not to be construed as legal advice. Each person's situation is different and requires analysis of the facts of the law. Should you have a legal issue that needs addressing, please retain competent legal counsel to assist you. Yeah. That's how you know you've got a lawyer doing this thing, because you've probably not seen that disclaimer very many times before. With that, let's jump right in. The CARES Act. So at the end of March, the CARES Act, a massive bill, several hundred pages long, and I was one of the lucky ones that drew the short straw at my office, and I got to read that thing. Created this thing called the PPP program that the U.S. Small Business Administration administered to deal with how do we create a situation, create the economics. We've got a lot of small businesses. They're getting beat up. They're struggling because you've got compelled shutdowns and closures across the nation. You know, people are hitting the unemployment line in droves. How do we protect these small businesses? How do we create a mechanism to incentivize retaining employees and keeping them on the payroll? Because by keeping them on the payroll, you keep them out of the unemployment line. If you keep them out of the unemployment line, that helps protect the state revenue streams. So they created this thing called the PPP program. And the main thing that we've got to understand is that this program was designed to assist small business. Now, we saw the news and we saw the issues where big business and publicly traded companies were getting in and taking advantage of this. But by and large, this has been a good program, and small businesses that need it got the assistance that they needed. There's still some money involved. One of the things that just happened not too long ago is, although the PPP program was set to expire on June 30th, a law was passed extending it to August 8th. So if you're a small business owner, if you're a dental office out there that haven't been able to take advantage of this program and you need to take advantage, there's still time. Make sure you're talking to your lawyers and your accountants to fill those those loan agreements and loan apps out correctly. But there's still the ability to be involved and take advantage of this program. One of the main selling points for small businesses is it's a loan designed to convert to what we call a grant. What that means is within the program, there were this loan forgiveness mechanism that was created that said, if you use the money for these certain things and you use it over this period of time, and then you meet these conditions, you can file an application and you can have those loan dollars forgiven and you not have to pay tax, you not have to repay that loan. Creates a really good mechanism to create immediate relief for small businesses. Main thing you had to do, retain employees. Now, as we've seen from the laws that have been created and how these things have adjusted over the last several months, retain employees, what it meant at the end of March when the CARES Act was passed, is different from what it means today with the Paycheck Protection Flexibility Act. So we're going to talk about that a little bit. The other thing you had to look at is it had a very limited allowable use of the funds. Now, typically when you see a US SBA loan, it's designed to create operating costs. Use this money to buy inventory and things of that nature in order to allow a business to operate. And it's funded through what's called the 7A program. PPP was also funded through the 7A program. But what they did is they changed. And rather than looking at some of that fixed operating cost, it looked at the employee retention cost. And it's really designed at payroll costs. The idea was we want to keep these employees paid. We want to keep them off the unemployment line. And we think, this was March, we think it's going to be short term, which has turned out to not be correct. But we want to use this money for these payroll expenses over a short period of time. It limited your use. It was designed originally to be 75% for payroll, 25% for mortgage, interest, rent, utilities, and things of that nature. That's kind of the idea behind it. And it was, in general, a very good program. Again, as I mentioned, the PPP Flexibility Act came out and said, look, as we moved through this pandemic, as we walked through these issues, it became very evident that the way it was designed at the end of March was not the way things were shaping up and working out in real life. Businesses were not reopening after 2 or 3 weeks. Many businesses were shut down until the beginning of May, some till the beginning of June. Some reopened in the middle of June only to be shut down again at the beginning of July. So that idea of saying, okay, we've got this loan and we have to use this money within 8 weeks of obtaining the loan didn't make sense. They also found out that, with that extension of the unemployment benefits, getting employees to come back to work was difficult. There were a lot of reasons why employees didn't want to come back to work. Some legitimate, some of them not. But for whatever reason, it was very difficult. And so the PPP Flexibility Act was designed to address some of those issues, make some changes to the statutory obligations and the statutory requirements of the Paycheck Protection Program, and allow it to be more workable under the situations that we're currently facing. Covered period was the first one. And I know, having talked with several dentists, having talked with several other business owners, one of the first things that concerned them, they go in, on April 3rd, April 4th, somewhere around that time frame, the PPP portals began to open up and people began to be able to apply for loans. Well, the first thing that concerned people is like, look, if I go out and I get this loan and I'm funded in the first 2 weeks of April, I've got 8 weeks to use this money. If I'm not reopened, what happens? Because in that situation, if you don't use the money in 8 weeks, you're not eligible for the loan forgiveness. So people were ending up with loans that they would likely have to repay, and many of these struggling small businesses may not have been able to repay it. So what happened is with the PPP Flexibility Act, they changed that. They said, look, the federal government looking at this going, this doesn't make sense as designed. So what we're going to do is we're going to increase that duration from an 8-week use covered period to a 24-week use covered period. What that meant is that, you've got these payroll costs that have to be paid. You can now stretch that over a longer period of time. And it gave some elections. If you received a PPP loan and you received it prior to June 5th, you had the ability to make elections. You could elect, if you wanted to continue to operate under that 8-week covered period, or if you found it more beneficial, you could stretch that out to the 24-week period. If funding occurred post June 5th, you don't have the option elect that 8-week covered period. If your funding is post June 5th, you are automatically in the 24-week covered period. But the idea was, as the government began to look at this and they began to understand all of the issues that are unfolding, was how do we make this program work the way we want to work? And they created that with the Flexibility Act. One of the other things that changed was that the ending date on that 24-week period was pushed to December 31st of 2020. Now, who knows what that's going to look like? Originally, when the law was created, those ending dates was June 30th of 2020. Created a very short window of time. The idea was, this thing is going to get passed in March. It's going to get used up quickly. We're going to run through the 8 weeks. We're going to be through this. And by July 1st, everybody will be moving on. Well, that didn't happen. So what they did is they said, okay, we're going to increase this to 24 weeks. We're going to expand that covered period date, termination date, which moved to December 31st of 2020. Now, with this recent change to the PPP dates, which extends the ability to use it to August 8th, you're likely to see some more changes down the road. People who are going through the PPP program now, they're getting access to funds. If they get one, say on August 7th, there's not 24 weeks between August 7th and December 31st. There's about 18 or 19 weeks, which means the government is likely to address this and extend that even further. So you've got to be thinking about this as you're looking at these issues. What's this timing going to look like, and what do I need to do? One of the things you want to do is, as you're choosing your covered period, you need to think about timing and potential changes for the program. Right now, there's a set of rules that talk about what can this money be used for? How long do you have to use it? What are these ratios looking like? What does employee retention look like? All of these rules are fixed today, but they can change. And as we've seen over the last 3 months, the SBA rules and guidance has changed frequently. If you get your application in, when you get your application for loan forgiveness in on one set of rules, they can't change them to your disfavor in the future. If your loan application for forgiveness isn't in, they can make changes. So you want to be thinking about and strategically making these determinations with your legal counsel and your accounting professionals. What's the best mechanism for me? If I'm looking at making an election on covered period, we know what the rules are today. We don't know what they're going to be tomorrow. what's the best way for me to do this? Now, one of the things that we look at and we're constantly thinking about and wrestling with is over the last 3 months, what has historically been happening, and it's interesting to use that word historical in the context of 3 months, so I'm not going to digress on that. But one of the things that we've seen over the last 3 months is as the SBA has been making changes, they have generally made changes that are to the favor of small businesses. You know, they've talked about audit periods and how they're going to do audits. And they're saying, well, anybody who's taking less than $2 million in a loan, we're not going to audit them. We're only going to audit those that are taking more than $2 million. We're going to presume that if they signed the application for the PPP loan, that it was done in good faith and that they needed the money. We're going to look at rules on how employee retention is handled and create exceptions. So as we've seen this develop, it's begun to get more and more favorable. That doesn't necessarily mean that that's going to hold true. Things can change. So one of the things that you got to be thinking about is as you move through this process, if you've taken a PPP loan, you need to be thinking about what are these changes that can come up and how do I strategically plan for these applications and these final moving parts that we need to deal with on our PPP loan forgiveness. Employee retention. One of the questions we get all the time, and we've seen it more and more, especially as businesses began to reopen and they close down again and then they begin to reopen. Do we have to maintain pre-COVID employment levels to maximize loan forgiveness? That's one of the places where the Flexibility Act did some things. Under the CARES Act, absolutely. If you had 18 full-time employees on February 15th, pre-COVID, yes, that's what you had to have when you filed your application for loan forgiveness. And if you didn't have that, then there was going to be an algorithm or calculation model that would proportionally reduce your loan forgiveness amount based on the number of jobs you lost. Under the PPP Flexibility Act, they said, no, you do not have to maintain pre-COVID employment levels to maximize your loan forgiveness. However, you have to fit within some of those exceptions. What are the exceptions? When you look through this, you're going, okay, I don't have to maintain those 18 employees. I can drop to 14, but if I drop to 14, how do I still maintain and get the maximum amount of forgiveness possible? Well, in order to do that, you have to show in good faith. In good faith, I put that in quotes because as a lawyer, good faith can mean a lot of things to a lot of different people in a lot of different contexts. It's one of those words that as lawyers we throw around because we know that if we throw it around, it's going to end up in a courtroom and get litigated. So when we look at this, what is it that you really had to do? It was really one of two things. You have to show an inability to rehire employees or similarly qualified employees for unfilled positions prior to December 31, 2020. So what happens is, let's say hypothetically, you've shut down, you've laid off or furloughed your staff. The local powers that be come out and say, okay, you now are able to reopen and re-engage. And you go back in and you say, okay, I'm going to send a letter or make the phone calls to all of my employees and say, we're reopened, we're opening for business, I need you to come back to work. Let's say you have a really good hygienist. That hygienist just says, look, I'm not okay with this. I don't think the issues have passed. I don't feel comfortable coming back to work. You don't have to hire the same person back. If there is another hygienist out there that is equally qualified, you can hire them. But let's say you find yourself in a situation where you're struggling to find anybody. You're seeing it in the legal business in some industries right now. It's hard to find certain types of employees with certain types of skills. So you lose one, that person's unwilling to come back. And you're out there trying to rehire and get someone with similar skill sets to come back. If you can't find them, if you've made a good faith effort, you've tried to interview people, you've taken out ads for employment, and it's just not working, you don't have to rehire just for the sake of rehiring. But if that's going to happen, what you need to do is you need to document. And so, like, you're calling your employees back to work, the best thing to do, call them back to work with writing, send them a letter, send them an email, do something on paper that says we are reopening, we are extending employment back to you, we are calling you back to work, please let us know. And then force them, if you can, I hate using the word force, try to get them to respond in writing. Oftentimes people want to pick up the phone and just say, I don't really want to do that. But try to get them to respond in writing so you have a paper trail. If they're a little leery about wanting to respond in writing, make sure you follow it up. Create that paper trail that says that if you tried to rehire and that person didn't come back, or if you made job offers and you couldn't get people to come to work for you, make sure you have this documented so that you can show your good faith attempts to restore employment levels. The other reason where you can avoid this is the inability to return to pre-February 15th staffing levels because of CDC, OSHA, HHS guidance related to social distancing, sanitary and safety protocols. You're really seeing this a lot more in the restaurant industry where they're restricting the amount of people you can have indoors. I don't know if you've seen it a lot. I haven't seen a lot of this in the dental side because you've got that separation. You've got the operatories. You've got one patient in the operatory. You've got maybe your hygienist and then yourself as the dentist. We haven't seen that restriction real heavily in the dental side, at least now. I know early on it was really difficult because it was really down to just emergency procedures only. But you're seeing this in some industries where they're restricting the capacity, restricting the number of people you can have in the business at any one time. And in those situations, if you've got staffing level issues because your business has been constrained because of the number of people that you're allowed to have in, because of some of the sanitary and safety protocols you have to put in place, that's the other reason that you can avoid or not have to go back to pre-COVID staffing levels. But the main thing is if you're not getting back to pre-COVID staffing levels, you've got to have this documented. You've got to have it written down somewhere so that if you're ever audited or if somebody ever asks or if you need to justify, you have a paper trail that shows this is what we tried to do or this is why we ended up getting prevented from being able to rehire to the levels that we were prior to February 15, 2020. The reason it's important is really what we're looking at. The PPP was designed to deal with payroll costs, as we talked about at the beginning. Under the CARES Act originally, you had to have 75% of the loan proceeds used for payroll costs. Now, under the old rule, if you didn't meet 75%, let's say maybe you met 71 or 72% of the money was used for during covered period payroll costs. So you didn't get quite to the 75% level. Under that rule, you were still eligible for loan forgiveness. However, in that loan forgiveness model, there would be some proportional reduction based on the lack of compliance with the 75%. So you didn't get 75%, you were at 71%, your loan forgiveness would drop by a percentage in order to kind of deal with that non-compliance. However, under the flexibility rule, or Flexibility Act, they didn't create an allowance to reduce or proportionally reduce the amount of forgiveness. It set a threshold. If you are less than 60% on payroll costs, then no forgiveness. The idea is we're telling you we want this money used for payroll costs. We want it used to retain employees. And because we're lowering the threshold that you have to meet, if you don't meet it, we're not going to give you forgiveness. I just saw a question pop in.
I was just going to read it to you.
Okay.
Will an increase in one employee's hours from 28 to 40 hours a week make up for another employee who used to work 12 hours a week who will not be returning?
Let me close this down. The answer is yes, that should, because when you look at what they mean by employee, they're based on full-time equivalents. So you could take, let's say you had two employees that job shared and one did 20 hours and one did 20 hours. That's one full-time equivalent. It's not the number. So when you look at your application, it should have had something that said FTE, full-time equivalent employee. So it's based on those number of hours. So if you had 2 people that work 20 hours, that's one full-time equivalent because that's 40 hours. It's based on federal standards, not based on state standards. In California, the FTE equivalent, I think I want to say is 30 hours. At the federal level, it's 35. Under the PPP, it's 40 hours. So if you had 2 employees and one's doing 28 hours and one's doing 12 hours, the one who's doing 12 hours doesn't come back, but the one who's doing 28 goes to 40. Those 2 together was one full-time employee. One doing all 40 by themselves is still one full-time equivalent. Can I answer your question? Perfect.
Hope so.
It's hard. I always want to make sure I answer people's questions. So I asked, did I answer your question? But I can't see you. So yeah. But anyway, one more came in. I'll let Noelle, you just interrupt me at any point in time. I'm very flexible on this.
Oh, it was a yes, thanks. You answered.
Perfect. Good.
Awesome.
The other thing that we need to look at is the deferral period. If you've taken a PPP loan, then under that PPP, under the CARES Act, it was originally set up to be a 6-month deferral. And the idea was you had 8 weeks to use the money. After those 8 weeks, you would get your 941s, you would finish your quarter out, you would submit it to the IRS, you would take care of all the payroll tax issues, you would have that information, you could then package up a nice little application, send it off, and everything was supposed to be processed. Once you sent that application off, it was supposed to be processed within 2 months and a determination made. Well, you figure 8 weeks, a little bit of time for application in 60 days, you had plenty of time in that window to not run over the 6-month deferral window. Well, when they created the PPPFA, they changed that. I said, okay, now we're going to 24 weeks. Well, that's almost 6 months. That's just shy of a complete 6 months. Then they extended the analysis time related to how fast does somebody have to get a response related to loan forgiveness. Instead of it being 60 days, it's now the bank has a 60-day window to make a determination as to whether or not to recommend forgiveness. After the bank makes a recommendation to recommend forgiveness, it goes to the SBA. The SBA has up to 3 months to review to make that determination. So you've added a potential 5 months of reviewing on this loan before that determination is made, plus the 24 weeks in order to deal with the way these things were beginning to unwind. The legislature, the Congress said, we need to extend this. So now what you're looking at is it's 10 months after the conclusion of the covered period, which means you finish, let's say you got your loan on April 15th, you are going to run until just shy of the end of September. Once that September date runs, you have 10 months from that point to work through the process of the loan forgiveness before you would ever have to make a payment on that loan. So they did some things to say, hey, look, we recognize there's some problems. We're going to make this a little bit more user-friendly and put these mechanisms in place so that people don't feel strapped. People don't feel like, okay, I've made this, I'm running out of 6 weeks. I don't have a response. I've got to make a payment. I've got a 2-year loan term, and I borrowed $200,000 in 2-year loan term at 1%. I've got to make a $10,000 payment or a $9,000 payment. What am I going to do? They created these rules under the PPPFA to make it so you could walk through this process and walk through it in a professional and a diligent manner. A lot of banks, people have been coming up raising questions like, well, I got my loan on May 1st, and on May 1st, I was supposed to be 6 months. A lot of banks have just by themselves already extended that deferral. I've seen emails from banks that say, look, well, because of the PPPFA, we are just going to extend the deferral period. If you haven't received one of those emails, you absolutely want to make sure you're chatting with your bankers to make sure you've got a good understanding of what that relationship and what that loan requirements are going to look at. The other thing to think about, under the CARES Act, what was determined is if you took a PPP loan under the CARES Act, there was a creation that said we're going to allow businesses to defer payment of certain payroll taxes. It was another way to create relief. However, what the PPP, what the CARES Act said is if you defer, if you take the PPP proceeds, you cannot, you're excluded from participation in deferring of payroll taxes. Well, one of the things that we've seen is that even with the PPP, in a lot of businesses, that was not enough. It wasn't enough to help them ride this economic wave. So under the PPPFA, they extended that. They said, okay, look, we've limited the ability to take advantage of this benefit. So we're going to roll that back. We're going to say, look, even if you've got a PPP loan, you can still take advantage of certain deferments of payroll taxes. So that ability exists. Now, what you got to understand is if you take it, you take this deferral, take advantage of this deferral, then you have up until December 31st of 2021 to pay 50% of that obligation. The remaining 50% is due December 31st of 2022. If you're going to make the election, you're going to work through some of this stuff, make sure you're working with your accountant. Make sure you're talking to your accountant. Make sure you're talking to your lawyer. Make sure you're doing the things to stay in compliance, because the one thing you never want to do is run afoul of taxes, especially payroll taxes. Payroll taxes will come back to haunt you. It is one of those things that even if you've got an S-Corp set up, your S-Corp will not shield you from personal responsibility on that one. So make sure that if you do this, you're making the election properly. Make sure you're strategically planning for how you're going to pay those taxes back. Because even if something really bad, I mean, we'll be honest, I've talked with a lot of businesses, and some businesses are not making it. Some businesses just are not going to survive this. If those businesses that don't survive take advantage of this, those individual owners of those business, regardless of the success of that business, still owe the money. So make sure that if you're working through and you're taking advantage of some of these deferral mechanisms, make sure you're planning for that. Make sure you're working with your accountant and your lawyer so that you can make sure that those obligations are covered. PPP loan forgiveness. This is the big one. This is the reason people took the PPP loan. This is why it was good. It was the ability to convert that loan to a grant so that you as the business owner didn't have to pay that money back. First thing, make sure you're working with your lawyer and your accountant to put together the best application for loan forgiveness. I don't care if I'm your lawyer or if somebody else is the lawyer. I don't care who you use. Just make sure you use a good lawyer and a good accountant to put this together the right way to make sure that you're protected. At the end of the day, that's what's most important. Make sure that you have confidence that you're protected and that you have everything put together to maximize that loan forgiveness. Make sure to document with employee information the payroll costs. If you look at some of the rules that are coming out and some of the guidance, it's talking about, you know, you've got to identify the employee by name, you got to identify their rate of pay, you've got to identify all these different mechanisms as part of the application for loan forgiveness to justify or support your request. Best way to do this, if you use like a Paycheck or an ADP or a payroll provider service, that's the best way to get those reports. Get those weekly or bi-weekly or semi-monthly or however you do your pay. Get those reports for each pay period and package that up. That's going to create an independent analysis, an independent verification of the money that was spent on payroll costs. Because if they're done right, you know, they're going to show you what's their gross rate of pay, what's the taxes that are withheld, what's the employer side of the taxes, what's the employee side of the taxes, what are the healthcare costs, what are the 401k contributions. It's going to cover that entire lineage or litany of costs that are expended on behalf of the employee. It's the best way, if you've got it, to be able to document everything that you need to document in order to justify and support your application for loan forgiveness. Finally, when you're talking about the PPP loan forgiveness, you've got to retain records. One of the things that came out early on is that there's the ability for the SBA to audit. Whether they will or they won't, I mean, we just have to be honest. There's something like 4.75 million PPP loans have been granted, have been funded since the beginning of April. That's a lot. That's a lot. Now, to put this into perspective, SBA, prior to this program, funded on average $21 billion a year in loans. $21 billion. The first tranche alone of the PPP was $349 billion or $369 billion. It was a lot. It was something in the order of magnitude was something in the realm of about 16 times what the SBA does in a year. With the second funding, they have funded well over $500 billion into PPP loans. They do not have the institutional mechanisms and the people resources to audit every loan. They're not going to do it. But what the guidance is saying is you need to keep your records for up to 6 years because there is a possibility that sometime in the future they may audit. So keep those records that justified your loan amount. Keep those loan forgiveness records and the records that you're using to justify the forgiveness, and keep that secure and keep that on file for the requisite period of time. That's kind of the PPP program and the issues you need to know about today in a nutshell. Ooh, question. Yes. Well,
we've got a question. If we rehire using the PPP money, and are we able to get full forgiveness? What will happen when the fund runs out and the business income will not be able to support that payroll? Can we furlough or adjust it later?
So what you have to look at and what you have to think about, you've got to be strategic on your rehire. You have 24 weeks to use the money, but you don't have to have your rehire numbers met until December 31st of 2020. So you've got to be strategic about where you rehire, because when you make your affidavit, it's at the time that money runs out or December 31st of 2020. It's one of those 2 days. That's the day that you have to make sure that as of that day, you have your employment status. Now, again, we go back to the employee retention stuff from a couple slides ago. You know, if you furlough them, you're not going to qualify under the inability to rehire, and you're not going to qualify under CDC or OSHA restrictions. Where that qualification happens is whether or not people come back and you have the ability to retain the employees. So once you've obtained the PPP money, you have to make sure that as of the date of your application, or December 31st, 2020, that you've got your rehire statistics, you've got your full-time equivalents. If you don't, then you have the potential to have that proportional set off and may not qualify for full forgiveness. Okay. We're going to move on. Employment issues. We have seen a lot of employment stuff come up. People trying to figure it out. I mean, you've got all sorts of things happening. I mean, within the Families First Coronavirus Response Act, you had about 2 or 3 different employment laws structures that got passed. Some of them under the Emergency Sick Leave Act, some of it under EPL, Emergency Paid Leave, some of it under the Family Leave Act. You've seen a lot of different things. And as you walk through this, you get, how do we navigate through? How do we deal with all of these issues? So one of the first things you have to understand is the idea with the Families First Coronavirus Response Act creates additional paid sick leave related to COVID issues. One of the first things that happens is it didn't really matter. Normally when you see these statutes get created, they're targeting businesses with more than 50 employees. Under this, no, it was businesses even smaller than 50. Businesses with less than 25, I think it was either 20 or 25, could qualify for exemptions based on determinations made by the Secretary of Labor. But the idea in general was that everybody would be responsible. Every employer had this obligation. So what did it do? Created 80 hours of sick leave. In order for that 80 hours to be available, it had to be predicated on one of these 4 scenarios. There had to be a current COVID diagnosis. People had to be, or a person had to be quarantined to prevent the spread of COVID. Now, the one thing that was interesting about this is when this passed, a self-directed quarantine, it didn't have to be a quarantine required by a doctor or a medical professional. A person who believed that they had been exposed or were immunocompromised, they could quarantine themselves. A person who was caring for another who was diagnosed or quarantined could qualify, or caring for a child because school or child care facilities were closed. This was big. When this first came out and went into effect, you began to see schools close, and people had to figure out, how are we going to deal with childcare? How are we going to deal with all these situations? It created a big problem for businesses because as employees began to leave, they were still obligated to make these sick leave payments without that production, and it created a problem. So you've just got to understand that this stuff is here and it's good. And this law had a sunset provision at the end of this year. So people have the ability to use this all the way until December 31st of this year. It also extended the leaves under the Emergency Family Leave Act, and it allowed 12 weeks for this situation. Now, the interesting thing about it is under the Emergency Family Leave Act, the first 2 weeks of leave were not paid. But the problem is, the reason they structured it that way is if we go back and look at the Emergency Sick Leave Act, which we're just looking at under the Families First Coronavirus Response Act, you had 80 hours of sick leave. So you got 12 weeks. The first 2 weeks are unpaid, but under the Emergency Sick Leave Act, you had to pay those, and then you got to pay 10 more weeks. In order for it to be used, though, your options or your reasons for this extended leave narrowed. It had to be people were unable to work or telework to care for a child whose school was closed. So if you were in a situation where you could telework, and I get it, in your profession, very few people can telework. It's hard to clean teeth and do procedures with somebody on the other side of a screen. But some of the staff may have been able to do that. Some of the front office staff, billing and things like that, maybe they were able to work from home. But for those that were unable to work or telework to care for a child, they were qualified under the Emergency Family Leave Act for this additional paid family leave. The other one was unavailable because of COVID diagnosis or COVID quarantine. In those, that required a diagnosis, generally by a CDC-approved test. The one thing that you had to understand is that although the first 2 weeks were paid under the emergency sick leave at full rate, the remaining 10 weeks were capped. It's capped at 2/3 of their pay, but no more than $200 a day. So if 2/3 of the pay was $100, you didn't have to pay them $200 for the day. You had to pay them $100. It was the lesser of the two. And really what they're looking at is the total payment is about $10,000 over that 10 weeks. It's about $1,000 a week. Just make sure that you're aware of how this is working, because this is still in play, and I believe it runs through the end of the year. One of the other things that we saw come up is, as people are struggling financially, they're trying to figure out how can we invade other assets that we may have. A lot of people have 401ks, and a lot of people look at the restrictions generally are very narrow as to why you can take a 401k loan and how much. Originally, it was you were maxed out at $50,000, couldn't take any more than $50,000 on a loan for certain issues. Under the CARES Act, they expanded that. They said, look, employees can borrow up to $100,000 from their 401k. However, they're making it a very, very narrow window as to when they can do that. One, if the person had been diagnosed with COVID by a CDC-approved test, they could borrow from their 401k, and they'd have a repayment period for 3 to 5 years to get that repaid. If that individual was not diagnosed, then if their spouse or their dependent was diagnosed, then they could make that borrow, because they've got to take time off from work. They don't know how long they have to care for a loved one. So they were allowed to invade and borrow the money. The last reason, individuals who experience adverse financial consequences because of a quarantine, being furloughed or laid off, unable to work because of lack of child care or closing or reducing business hours, or any other factors determined by the Secretary of Treasury. This was that broad sweeping thing that said, look, if there's anything that happened, if for any reason a person is having financial consequences, and it can be at all attributable to COVID, we're creating a broad enough mechanism to allow them to borrow from their 401k. So the one thing that you need to do is as a business owner, if people are coming and asking you about these issues, make sure you're talking with your TPA. Make sure you're talking to the administrator of your 401k plan, if you have one, as to what this looks like so that you can take those benefits and apply them to your employees. I know that in talking with some of the TPAs that I work with and represent, they've just said, hey, look, the way this statute is written, we don't actually have to do this amendment for another 6 months. So we're allowing people to take advantage of this provision. We just, as the business, you've got to make sure that if your staff takes advantage and you allow it, you've got to make sure that your plan gets amended to be compliant with the law at some point within the next 6 months. So just keep that in mind as you navigate this pandemic. Employment issues continued. I see this question all the time. I've reopened, but my employee refuses to return to work. What should I do? You know, a lot of people got laid off. I mean, you saw the numbers at the end of March going into April where the unemployment statistics were 3.6 million and 4 million. I think the highest one I saw was 6.2 million people file for unemployment nationwide in the span of a week. You saw this massive amount of unemployment. How do we deal with the situation where the employee refuses to return to work? Under California Unemployment Insurance Code Section 1256, employees that voluntarily quit are not eligible for unemployment benefits. This is important because as you look at the Code of Regulations and decisions, people who don't come back to work, they've been offered rehire, they are deemed to have constructively quit. You can see that, 22 Cal Code Regs 1256 sub 1, employees who fail to return to work may be deemed to have to constructively quit. We've seen this play out more and more and more and develop over the years that say, look, you have an opportunity to go back to work. We get it. You may not want to, but you have an opportunity. Unemployment is designed for people who are out of work when they don't want to be out of work. It is not designed for people who are out of work and don't want to work. So under the law, the way it's developed is that if you are rehired or offered rehiring and you don't come back to work, you've constructively quit. Because as they've developed these regs, they've gone down to say that an employee has an obligation to preserve that employment relationship. Now, there's some things that are carved out, and one of the things that we have to be careful about is why did they not come back to work? There's case law that says that if they did not come back to work because their inability to obtain childcare, and this is a case that was decided many years ago, that is not a constructive quit. So you have to be thinking about this. You have to be analyzing what are the reasons that they're giving for not coming back to work? Is it because they don't want the risk? Is it because they're making more money on unemployment? Literally, I talked to a business owner and I asked them, and they were struggling to rehire. And they told me the reason they can't rehire, the reason their employees won't come back, is they were making more money on unemployment than they were making working. That is a reason to lose the unemployment benefits. But if their reason is saying, look, we've got this issue, maybe it's one of those issues within the Families First Coronavirus Response Act that says, look, I can't come back to work because my kid is out of school or my kid's daycare is closed. That in that situation is likely not going to be determined to be a violation of the rehire. But you've got to be thinking about this. The reason you've got to be thinking about this is under the SBA guidance. One of the things you're talking about is in order to get that employment relief, and to get the loan forgiveness relief, you've got to get that employment rehired. And if you can't get that employee rehired, you've got to find similarly qualified people. Under the SBA frequently asked question number 40, employers may be required to report employees that reject offers of reemployment. And the reason this comes out is because under the EDD guidance, when you look at this, and that's the website right there, down there, that is all about COVID-related issues and dealing with employment. One of the things that they talk about is the state is aware that people are refusing rehire. And under some of the guidance, it suggests that if you know that a person is not coming back to work and it's not for a protected reason, you may, as an employer, have an obligation to report that individual to the EDD. What the EDD does with it is up to them. But you as an employer may have that obligation to report them, because the idea is they do not want to be paying unemployment benefits to people who have been offered an opportunity to come back to work and are simply refusing. So you've got to be thinking about this. You've got to be thinking about it from the concept of how do these obligations in employment play in with my need to seek PPP loan forgiveness? How does it play with the unemployment requirements and my reporting requirements? You've got to be constantly thinking about and analyzing these issues. Wow, I'm on time. This happens very rarely. I tend to, as a lawyer, I tend to bloviate and tend to go way over time. But one thing I just want to leave you with, this is not ending anytime soon. We're going to be navigating these issues for a while. And as the COVID pandemic continues to develop, regularly check for updates. Information at the state level, at the county level, at the agency levels, you know, they're changing all the time. Make sure you're checking. Make sure, if you're not checking, make sure you've got somebody on your staff that is designated to be following these issues and where to look so that they know what do we need to do to maintain our compliance with the laws as they're changing. If you have any questions, you know, my law firm, we are putting out information all the time. We spend a lot of time, especially with the PPP, because of a lot of the business work we do, getting PPP information out there and getting employment information. If you have questions, if it's coming out, log on to our website. It doesn't have everything, but it's got a lot. And we've got an entire section just for the COVID stuff. You can jump in there, you can get a lot of information. But make sure you've got somebody checking in on that. Pay attention to the forgiveness issues and work with your professionals to make sure it's done properly. These rules, again, they're changing a lot, and so you want to be strategic about how you're timing your forgiveness application if you've got a PPP loan. Employees may be reluctant to return. Understand your obligations. You have a role to play as well if they fail to return and why. But you also, more importantly, need to be thinking about and understanding the community sentiment related to what's going on and how do we navigate and operate our business. I mean, that is, you know, businesses have been beat up in the media. Small businesses have been beat up about only caring about, you know, wanting to chase the economics, but that is not true. I've met a lot of great business leaders and a lot of great business owners, and really, you know, their heart is for making sure that their staff, making sure that their patients, making sure that their clients, and making sure that their community is safe. That seems to be a common sentiment with the business owners that I've been working with. They want to make sure people are safe. That is number one priority. They also want to make sure that their business is healthy and protected, and they want to make sure that they're contributing to society. So continue to take those steps. Understand the leave and the relief issues related to COVID. And again, remember that it's constantly changing. I mean, it seems like at 1 o'clock every day, something is coming out and changing how we're operating and what we're doing. Make sure you stay on top of that. Make sure that you're following. And I've had a blast chatting with you guys. It looks like we had another question come in.
Yes, Lori asks, we are a small dental office and cannot afford to pay an RDH out on emergency family leave for 10 weeks. How do we apply for small business exemption for this?
So that's something that we're working out. We haven't seen a lot of guidance come out on that because really, if you're small business, and define small, are you less than 20? Less than 5 employees?
We're waiting to hear. Less than 10.
Okay. So less than 10, you know, we got to take a look at, you know, are you between the 5 and 10? Because a lot of times in that 5 to 10, the rules are much more flexible. And what's really been designed in the way that these rules initially came out is you make the determination that you have to make. And then that application, that application for relief or that decision gets made later. Now, I don't like the idea of it gets made later, because if it gets made later and you're deemed to be wrong, you then have to pay back pay. So what we're telling a lot of people is like, look, you got to make the business decision. You got to work through this. At the end of the day, if it's legitimate and you can't do it, I don't foresee you being held accountable for that. But it's kind of that everything's in the air and I don't have a great answer. And I apologize.
Any other questions out there?
Looks like no questions. Again, thank you. You guys have been fantastic. I always love the opportunities to get down and speak with the members of SDDS. You guys are very fortunate to have a great organization working with you all. If there's anything we can do to help, by all means, reach out. We'd love to help you. You guys are great.
Oh, one more Q&A. What do we got? Oh, it was a thank you. So thank you, Keith. SDDS really appreciates you being here. This was very informative.
My
We
pleasure.
really appreciate it.
You guys have a great weekend. Be safe. Take care of your patients and take care of your businesses. I'm done.
All right, thanks, Keith.
How do I turn this thing off?
There should be an end meeting button.
Okay. Do you need to put the pause or stop the?
I did.
Okay, perfect. And I can, let me find it. I got to stop share, and then I can get there we go. Thank you.
Thank you so much. This was great.